Morning.
I'm aware of an emergency motion for a continuance. I'm not aware of any additional motions that we filed. And I have an oral tennis motion that I'm going to make.
All right, I have your motion to continue.
I think we've articulated it well in the motion, Your Honor. I don't see any reason to go into the specifics any deeper than we delineated in our motion and legal argument. In a nutshell, though, given the recent rulings by the court, especially as it relates to the deprivation of Mr. O'Keefe at counsel table, and what I understand is now an issue about even having his laptop connected to an HDMI cable. Apparently, court services will not allow that because it extends beyond counsel table, and they've deemed it a tripping hazard. We have a lot of our court services to extend the cable, but apparently not. So, yes.
There was no matter pending before me. There was a bunch of emails going back and forth, but I don't rule on emails, sir.
Judge, it's just so we're clear, it's my position, this is not an issue that should be dignified by a formal motion. Connecting my assistant's laptop to assist me in defending Ms. Benefield and requiring a formal motion for something so perfunctory is an indication of just how difficult the court has sought to make this for the defense from day one. That's my position, Your Honor, respectfully.
So I haven't even been mentioned, other than the fact my judicial assistant was copied on some emails going back and forth about this issue. Did you just expect me to jump in?
Yes, in fact, I did,
Okay,
Your
well,
Honor.
that would be inappropriate. So tell me where you want to run the cable from and what the problem is.
We need the laptop connected. As the court well knows, Mr. O'Keefe has not been permitted to sit at counsel table, so the cable needs to extend to this back bench for Mr. O'Keefe, and court services.
To where?
Where?
To your table?
To the back bench. It needs to go past our table.
On the case law and the rules is the unlicensed practice of law. If Mr. Taylor is talking about just having him turn it on, then that's a different story, but in the email, it was not clear. And so I emailed your JA to say, hey, can we talk about it Monday? So if it's just to hit the button because Mr. Taylor's incapable, then I would not have an objection.
Okay,
Thank you.
yeah, just run the cable. We'll get duct tape. In fact,
Yeah, and as the court knows, Mr. O'Keefe has never practiced law in Your Honor's court, so I don't quite understand the state's position, but he's going to hit the button.
All right, the great motion of the cable is resolved,
Thank you.
and we can move on to the
I am deprived of that assistance. So we would have to go back through a lot of our exhibits, and as I've articulated in our motion, the reasons why we think continuance is appropriate. That's our emergency motion to continue.
Thank you. State?
Judge, we object, and we find that there's no valid reason for a continuance.
All right, the question I have is, late last week, I don't know if it was Thursday or Friday, I received a motion, I don't know if I have it in my pile, under 90.702 Daubert for the defendant's expert, and I don't remember his name, but it was referenced last week. So,
Bruce Ferris, yes, sir.
all right, typically that would be heard prior to trial. Sufficient time for both sides to have a ruling and be prepared.
I understand, Judge, and that was a response really to what happened on Tuesday, because we thought we had handled it the appropriate way, and evidently we had not, and so I was trying to correct it. I did put in the motion that I understand it's normally a pretrial motion, but in order to not have Mr. Ferris have to come here and try to handle it this morning when we're trying to pick a jury, we have no objection to just having it basically Thursday, whatever morning he would be here, because the state has objections to his testimony on many grounds, and we have a fear that it's going to be a situation where we're objecting and objecting and objecting, which is going to be awful for the jury and for the court. It's going to delay things. So that was our hopes, that we could have some kind of hearing when Your Honors thinks it's appropriate to discuss whether or not his expertise as a domestic violence expert qualifies him to testify during this trial.
All right.
And, oh, I'm sorry, sorry, Judge, I left out a part. Our other thought was, some of it depends on what comes out during trial, and so it's kind of hard to handle it pre-trial. As we discussed last week, some of the other things are very difficult, and which is the other reason we thought it might be more appropriately heard right before he was gonna testify.
All right.
Thank you, Judge.
The procedural hurdle that raises is going to be, if I deny the state's Daubert challenge, or whatever the ruling may be, but it's against the state, you certainly have the right to appeal. And I think the problem would be if we're in the middle of trial and it's late this week or sometime early next week, the difficulties that could raise.
We understand, Judge. I think we're past that point we're at the point of, we're ready for this trial to go and to get it through, so
Okay.
thank you.
All right. Yes, sir. Any final thoughts?
Well, as I raised earlier, not only did the court issue a cutoff date for motions, but both sides signed off on that cutoff date, and that cutoff date is long past. So this request for a Daubert hearing is beyond tardy, and I think the court should deny it. It's as simple as that.
Well, we'll cross that bridge when we come to it. I think both parties were filing motions and asking for hearing time well past the cutoff. All right, in considering the motion to continue, we start with the, although I'm not sure all of these factors or elements were argued by both sides. Whether the denial of the continuance creates an injustice for the movement, whether the cause for the request was unforeseeable, whether the cause for the request was dilatory practices, and whether the opposing party would suffer any prejudice, injustice, or convenience. Looking at the Fleming factors, I don't need to make a great deal of factual findings, but the main thrust, as I'm understanding it, from the motion and the argument today is the issue of Mr. O'Keefe sitting at council table. I think I've made sufficient allowances for him to be near and present, but not at council table. I don't find that there's an injustice. Unforeseeable or unforeseeability. Certainly, I don't think this is an unforeseeable ruling based upon the scant case law that's available and the fact it's a matter of discretion for the trial court. I think certainly both sides have noticed and can expect, as experienced attorneys, that sometimes the courts rule favorably to you and sometimes they rule against your position. And if there's issues that need to be brought up before the court well in advance of trial, they should be. But when issues are brought before me by motion, I rule on them, and I have not been dilatory in my rulings. And as opposed to the other side, certainly this case has been pending since around September of 2020. It's now July of 2024. I think the state has every right to and is ready to go to trial. I think both sides are and should be ready at this point. There's been more than sufficient time for preparation. Again, the incident complained of and the information happened in September of 2020. I don't find that there's any prejudice from the rulings that I've made regarding Mr. O'Keefe and where he's sitting. So in addressing the Fleming factors and the McKay factors, based on the obtained factors, I will deny the motion to continue. All right, was that all of your motions, or was there?
No, I have two left, Your Honor. The first one is pretty small and simple. I wonder if the court would have any objection if we bring in to assist with the mechanics of this trial, a very small portable table so that Mr. O'Keefe can have something to put his laptop on. We can put it back there,
How big of a table?
like a little tray table, Your Honor.
Like a dinner table or a TV tray?
Yeah, the equivalent of like a TV tray.
If it's the size of a TV tray, I think that'll be fine because it'll just sit right in front of him and that shouldn't block ingress or egress from that side.
Very good. Thank you, Judge. My last motion, if I may.
Yes, sir.
Your Honor, this is a motion for the court to voluntarily disqualify itself. And if the court would be kind enough to allow me to make my record, I'd appreciate it. This is an appeal to the court's sense of honor, integrity, and to the oath that the court took when sworn into the office that it now holds to support and defend the Constitution of the United States, specifically the Sixth Amendment right to a fair trial, and the Florida Constitution's Due Process Clause in Article 1, Section 9 of the Florida Constitution. The court's order of September 18, 2023, denying Ms. Benefield's request for judicial immunity, on page 26 in the third paragraph, Your Honor, reads as follows. Considering the totality of the competent and substantial evidence admitted during the stand your ground hearing, the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands as she told Dr. Broder she would. Now, Had the court issued a neutral order that would have or should have read that the state has met its burden by clear and convincing evidence for purposes of the request for judicial immunity and the defendant's motion is denied, it would have gone on and said whether the shooting was justified is a question of fact to be properly submitted to a jury at the trial of this matter. How can Ms. Benefield possibly receive a fair trial with the conclusion that the court reached in that order? Make no mistake, that order says Ms. Benefield is guilty of the crime with which she is charged. Ironically, we're here this morning to select jurors, and the court is going to instruct them that they are to presume Ms. Benefield innocent of the charges against her. How in the world can we expect that of the jury when the court cannot extend that presumption and honor it based upon what the court's words, not ours, what the court wrote in its order? That conclusion specifically, Judge White, help explain why at this stage the court has, among other things, quashed defense witness subpoenas and told the defense they can prove it some other way when it's our case and our right to a fair trial, and we decide the best manner in which to present our case within the rules of evidence and criminal procedure. Why, Your Honor, has denied Jack O'Keefe from assisting me in the trial of this case, and why the court at the last hearing that we had on its own suggested to the court that perhaps the right action on behalf of the court would be to file, on behalf of the state, would be to file a Daubert challenge. The record of that hearing will specifically note that the defense requested a Daubert challenge in response to the state's motion. The state never did. The court suggested that to the state at that hearing, and lo and behold, the very next day, the state filed a motion requesting a Daubert challenge. As the court knows, according to Florida Statute 3810, you can move to recuse the court based upon demonstrated bias or prejudice. Rule 2.330 of the Florida Rules of General Practice in Judicial Administration likewise provides for the disqualification of the trial judge. Now here's the problem. There's a time limitation. It's imposed in the Rules of Judicial Administration and the case law, and frankly, I missed it. And I missed it because at the time the court entered its order on September 18th, 2023, it was quite some time following the stand your ground hearing, and we were not only focused on filing the appeal, but by the time the appellate court acted and the second DCA denied our motion, I had just missed it. And I take responsibility for that. That, therefore, is why I asked the court, based on its order, to voluntarily take the high road and step aside voluntarily and give, in doing so, objective recognition to the oath Your Honor took to support and defend our constitutions, which includes, as the court knows, an opportunity for a fair trial by an accused, by an impartial jurist. So, I asked the court to do the right thing. There's no getting around what the court wrote in that order.
Would you like to be heard?
Judge, I would just like to say that at a stand your ground hearing, the court is the trier of fact, and the court does need to make factual findings. And the fact that that is being held against the court, I think, is quite unfair. The court is not the trier of fact in a jury trial. The jury is. There has been nothing in the court's rulings to show any animus towards this defendant. I quite frankly think this is the defendant's MO. This is what she does. When someone doesn't agree with her or a judge does not agree with her, she does a motion to recuse. I feel like this should have been done a year ago if it was going to be done. It was only done at this late time because of the court's rulings did not go in the defense's favor, and this is their last-ditch effort. The state would also say, if the court was inclined to grant this, that we just flip-flop judges right now and start this trial this morning. Thank you.
All right, thank you. Any final thoughts on your motion?
I'm sorry, Your Honor?
Any final thoughts on your motion?
No, sir.
All right, thank you very much. All right, so the jury questionnaires, we don't have them yet? 70 jurors. All right, so they're going to be sending up the questionnaires. We're going to get them about 10, 15 minutes, I would think, according to the clerk. And we are going to have the panel of 70. So for those of you who are here in the courtroom, the veneer panel that we're going to bring up is going to take both sides of the courtroom. So what I've done is I've asked court administration to open up another courtroom that will have audio or video so you can listen in and it'll be made available. And that's courtroom 5A. 5A. So 5th floor, courtroom A. In fact, it's basically just right down below where we are right now. And that'll be open for the jury selection process. So at this point, I guess we'll take a break, and there's not much to talk about until we get the questionnaires. Remember, I'm going to make the initial statements to the jurors, welcoming them, giving them some background information. We're going to get through the charges, the parties, the witness lists. If you haven't done it already, I need the witness lists of witnesses you expect to call. So when I'm introducing everybody, the parties, the folks in the courtroom, so the jurors, potential jurors have an understanding, I need your witness list so I can go through that. We'll then cover the substantive portions of what I'm going to cover for the jury selection are really just going to be hardships and knowledge about the case. And for those folks who don't express any pre-existing knowledge about the case or the facts, I'm going to then let them go to lunch, it'll be an early lunch, ask them to be back downstairs probably around 1:15. This is the plan. We know about the best laid plans.